All right, let's go ahead and start. Let's put phones away. So my mom's in town from Baltimore, and usually she just comes for a long weekend. She's here during the week because my kid's in the middle school musical. She wanted to see it. She's like, "Can I come to your class this morning?" So I said yes, but she's now late. So we'll see. My mom might walk in here in a couple minutes. We'll see. Now we're going to look every time the door opens. Let me get everyone to take out a sheet of paper and put your name on it. And make sure you get me papers if you haven't gotten this to hard copy yet. But take out a sheet of paper, put your name on it. Question number 1. In a single sentence, describe to me one provision of the Affordable Care Act, also known as Obamacare, and tell me what the Supreme Court did with it. I don't care if you get its name exactly right or whatever, but just tell me a name or a description of one provision from the law and tell me something about what the Supreme Court had to say about that provision. Grab a sheet of paper. Grab a sheet of paper, put your name on it. First question was, tell me, describe one provision of the Affordable Care Act, also known as Obamacare, and tell me what the Supreme Court did with it. Question number 2, do the same thing again with another provision. Tell me a second provision of the Affordable Care Act and tell me what the Supreme Court did with it. Grab a sheet of paper, put your name on it. I'll give you the questions real quick. Question number 1 is describe one provision of the Affordable Care Act, also known as Obamacare, and tell me what the Supreme Court did with it. Question number 2 is do the same thing again with a second provision. I don't think I'm going to collect them. I was on the fence. Well, let me do this. So when I do these kind of in-class writing prompts, we usually grade them with like a check or a check plus. Check plus means you got both questions, at least approximately something good there. Raise your hand if you think you just got a check plus on this. Check means you've got something pretty good for one of the questions. Raise your hand if you just got a check. All right, raise your hand if you don't think you would have gotten either one of those. All right, so obviously it is just, I don't want to grade them. We got a whole other stack of papers to grade. It is mostly just a reminder to you all, hi, my mom's here. I told them you were coming. You can sit anywhere. It's just a reminder, obviously, that the class goes better if you're doing the reading, so I don't have to talk to you for the whole time. You got more to say to me. Okay, so our focus today is the Affordable Care Act, also known as Obamacare, which was enacted in March of 2010. How old were y'all in 2010? 11. Yeah. So raise your hand. Not from anything that you might or might not have just done in the reading for today, but raise your hand if you remember anything about the enactment of the Affordable Care Act. Then what do you remember, Colin?
I remember that it passed without Kennedy's support, which was kind of unique because...
Oh, on the Supreme Court? Oh, you remember the Supreme Court decision?
Yeah.
Okay.
Yeah. Which was unique because most people thought it would have a chance, but it was going to have Kennedy's support.
Sure. So the law was enacted in 2010, and then it was challenged in the Supreme Court. And we'll talk about this. The Supreme Court upheld most of it in a 5-4 decision, right? Okay. What else does somebody remember? Even just about the law itself, not necessarily the Supreme Court decision. Yeah.
I remember that after it was passed, there was a lot of issues that had happened with people trying to enroll in it.
Mm-hmm.
The website was down.
There was a website issue. Yep. Yep.
It was a really big deal. I was working at a drugstore at the time. People put medication.
Oh, for sure. Okay. Jack, what do you remember?
I remember during the passing of the bill, single Republicans switching over to vote in favor of the ACA.
Yep. Vanessa, you can pass those handouts now. Thanks. Anybody else remember anything about the enactment of the Affordable Care Act in 2010? So I would, Colin?
I mean, it imposes a fine if you don't have approved nationally approved healthcare. Come tax season, you have to pay somewhat substantial fine, which people were complaining about, but ultimately, it lifted some of the burden off the taxpayers for healthcare support.
Sure. So I'll fill in some of those details. So, so we're, for this purposes of this class, we are mostly interested in the constitutionality of the law. But I feel like we got to spend at least a little time on policy and politics leading up to the law, right? Just to set the stage a little bit. For any issue that we're looking at this semester, we might talk about all three of these things, right? They're supposed to be three different questions, right? But they do overlap and intersect and influence each other, right? So one is, what is the policy issue that we are talking about? What is the important public problem that government is trying to solve for us, right? So if we were talking about, capital punishment, right? We could have a discussion about what does the evidence show about whether the death penalty serves some useful functions, right? Does it help deter criminals from engaging in crime, for example? We could also have questions about what are the best procedures, if we're going to use the death penalty, what are the best procedures to make sure the system is fair and not making mistakes, right, and not sentencing innocent people. So those are questions of policy. We could also have a discussion about the politics of it. Well, why is it that most Republicans support the death penalty and some Democrats do not? But some Democrats still feel political pressure much of the time to maybe feel like they should support it. What are those political debates about? What are the political implications of passing laws that either expanded or restricted the death penalty? And then we could have a discussion about the constitutionality, right? If Congress imposes a death penalty law and somebody challenges it as a violation of the Eighth Amendment, then that's a question about its constitutionality, right? So we want to get to this on the Affordable Care Act, but I feel like we need because y'all were 10 years old when this was passed and you don't remember it as fresh as I do, we got to do a little bit of this first. So raise your hand if you have car insurance. Why do you have car insurance?
It's mandated by laws.
Yes, you are required to have car insurance. Why is it mandated? Why does the government say you got to do that?
Probably because getting in a car accident is a really costly thing, and most people couldn't afford to pay off like interest from it.
And so if you did not have car insurance, and yet you did have a car, and you were driving around, and you crashed into somebody, what would happen?
It would cause like extreme liability damage to other people, so it falls under the general welfare clause where the government can levy like some sort of tax if it's in the general welfare.
Okay, but just back up before that a second. Just suppose you're just driving around. Leave the government's powers out of it for a second. You're driving around and you crash into somebody and you don't have car insurance. What's the immediate effect of that?
You pay for the damages to them and their car.
And you got no money. And so then what's going to happen?
You're going to court, most likely.
And then what's going to happen? Yeah, Quentin?
You can pay.
And so what's going to happen to the other guy? He's going to have to pay for it. You crashed into him, but he's going to have to pay for it. If you have no insurance and no money, he can try suing you, but if you don't have any money, right, that's not going to get him very far. Right? And that is not fair. Right? So as a condition of having a driver's license, the government mandates that you have car insurance. Car insurance is a product that is purchased through private companies, and the concept of insurance, right, the way that it works, is that all of us are going to pay into the system all the time, and most of us, most of the time, are not crashing into anybody. So if you are a very good driver, and have been driving for however many years y'all have been driving, 5 years or whatever, and have never had an accident, then maybe it seems unfair. Okay, why am I paying for this? The government has required me to pay for this. I never crashed into anybody, right? But it's a social regulatory system that is trying to spread the cost burden in a fair way across all drivers, right? Most of us are not going to crash into people most of the time, but you never know when it's going to happen, right? You're driving too late at night, you fell asleep at the wheel, you crashed into somebody. Terrible, right? Accident, right? Hopefully nobody gets hurt, but there's a lot of property damage, or if somebody gets hurt, then there's medical costs too, right? This is the fairest way that the government has come up with to try to spread those costs, right? And so that the very concept of insurance is that you are paying for something that you may or may not actually need to use, right? But we are all required to pay for it to socialize those costs, right? Much of the health insurance market in the United States is private. Not all of it, but much of it. There are private health insurance companies that sell insurance policies, just like there are private car insurance companies that sell car insurance policies. And at the time the Affordable Care Act was enacted in 2010, so before that law, what do you think might have been some major policy issues that the government might seem like we got to do better, we got to address? Yeah.
I remember policies or just health insurance could decline you based on prior conditions.
Yeah, so this was a big issue, right? Insurance companies, if anybody works for a health insurance company or your family members work for a health insurance company, I don't mean this personally, right? But the business model of health insurance companies is to deny coverage to people, right? The way we are going to make a profit is we get lots of people paying into the system, and we do our best to avoid paying the claims when they get sick. That is the business model. That is how they make a profit, right? And so they would repeatedly just refuse to insure people if you had been too sick in the past, right? If you had a previous diagnosis of cancer, why am I going to sell you an insurance policy? There's a good chance that that cancer is going to recur, right? And that's going to be higher than average healthcare costs. No, we decline to cover you. Happened all the time. In addition, sometimes when you actually did get sick, they would search through your history and see if they could find any technical violations of the policy on your part, and then they would kick you off just at the point at which you did get diagnosed with cancer. And then they would refuse. There was also a lot of fine print sometimes, just imposing strict limits on what was actually covered. So you're paying into the system over time, and you think you're covered, you got health insurance, you're good, and then you do get diagnosed with a very expensive, a disease that requires very expensive forms of treatment, and it turns out, oh, there's a lifetime cap on how much your policy will actually pay, right? It actually will only pay a maximum of $200,000, which goes quick if you're in chemo, right? So that happened all the time, and people were complaining to their representatives about it. What else was wrong with the system? Anything else that occurs to you that government might have been trying to address? Yeah?
And there are no more like basic coverage to people who cannot afford insurance.
Yeah. Many people didn't have insurance because they couldn't afford it. Right? So we now have two reasons that lots of Americans did not have health insurance prior to the Affordable Care Act. One reason is insurance companies would refuse to provide it to them because they had previously been sick. And the second reason is, I never been sick before, but I don't have enough money to afford health insurance for myself and my family. There were something on the order of 50 million Americans with no health insurance prior to the Affordable Care Act, either because they couldn't afford it or because insurance companies said they were uninsurable.
Some people were being sold like really substandard policies that really didn't cover them for some things.
There were health insurance policies that didn't include maternity care, right? And you didn't even know that when you got the policy, and then lo and behold you get pregnant, and then no prenatal care, right? No coverage for labor and delivery. Labor and delivery is an expensive medical procedure, right? Most people cannot pay for it out of pocket. So that's another issue. What happens if you don't have health insurance and you get sick or in a car accident? What happens?
Especially if it's like emergency services, a lot of those people will still be treated, and that's a burden on the taxpayers.
Yeah, emergency rooms are required to treat you if you have an emergent condition. It's required by law, right? They cannot turn you away from an emergency room. So if you get hit by a car, you go to the ER and you are treated. Or even you just get a bad flu and you don't have a primary care physician because you don't have health insurance, and so you wait till it's really, really bad, and then you go into the ER to try to get you're dehydrated, right? And now they got to put you on fluids, right, in the ER rather than visiting a doctor early on. Either way, they're required to treat you, and somebody is paying for it other than you, right? Either the government is paying for it, or the cost is being socialized over other people with health insurance, right? So the hospitals are charging rates at a level such that the amount that they get from their paying customers with insurance is enough to cover their costs for the non-paying customers who come in. All of these are major policy problems affecting millions and millions of Americans that the government has long been trying to address, right? Occasionally there were some piecemeal reforms enacted, but the Affordable Care Act is the first major federal intervention into the healthcare industry since Medicare and Medicaid were created in the 60s.
Wasn't there also some debate about the quality of care being provided by doctors because the ERs were so backed up because of stuff like that, and doctors' malpractice insurance is skyrocketing to also subsidize those costs?
Sure, and if you look at it comparatively, right, if you compare the United States to other democratic nations, we were spending more money on healthcare for worse outcomes, right? Life expectancy, not good. Look at the international list. We're still not good. Right? Infant and maternal mortality rates, not good. Right? Poor health outcomes at higher cost. And with 50 million people uninsured and lots of other people with substandard policies. Right? So huge problems to address. The politics of this, right, are extraordinarily difficult. Right? President Obama had large Democratic majorities in both houses of Congress following the 2008 election. He said this was his single most important domestic policy goal. I mean, he inherited a historic financial crisis, and we had to figure out how to get through that first. But then, once we were pushing past that, single most important domestic policy goal was universal health insurance. And he had large Democratic majorities in both houses of Congress, and it barely passed. Right? From President Obama's perspective, if you ask the Republicans in Congress, they will tell you a different story, right? But let me give you President Obama's story for a minute. From President Obama's perspective, he bent over backwards to work with Republicans on this issue. He said he wanted it to be bipartisan. He said he held a meeting with the entire House Republican Conference, no Democrats invited, just every Republican member of the House, a televised meeting where for 2 hours they grilled him with questions about health care policy, right? He worked with Senate Democrats to lead bipartisan negotiations on the Senate Finance Committee that went on for 13 months. 100 amendments that were proposed by Republican senators were added to the Affordable Care Act in that process, right? They proposed some amendments that were rejected by Democrats, but 100 Republican amendments were added to the bill during that process. The central provision of the law, the individual mandate provision, which I'll say more about in a minute, was originally a Republican idea. The first time it was ever enacted anywhere was in Massachusetts, where it was Governor Mitt Romney's policy proposal. So Obama was like, I'm bending over backwards to work with Republicans, and none of the Republicans voted for it. One Republican guy in the House voted for it. 0 Republican senators voted for it. It barely passed, and Republicans obviously have been opposed to it ever since and have been trying to get rid of it. They have been trying to repeal it in Congress. They had some unsuccessful attempts last year. They did repeal one of its major provisions in the tax bill that was enacted in December. And in addition, they also tried to repeal it in court, if that's the right way to phrase that, right? They attempted to block it in Congress, and they failed. And so then they filed a bunch of lawsuits and attempted to persuade the court to strike it down. And so that's what we want to look at. So first let me give you 3 main provisions. The law is like 900 pages long, right? There's tons of stuff in it, right? But let me give you 3 main provisions that we're trying to address those policy problems that we just talked about. The law significantly expanded Medicaid. So Medicaid was an existing governmental program dating to President Johnson in the 60s that provides government health insurance for certain categories of people in poverty, right? And the Affordable Care Act substantially expanded Medicaid. Under the Affordable Care Act, it said that anybody with a family income at or below 133% of the federal poverty level is now eligible for Medicaid, which was a huge expansion. One complicating feature of this part is that Medicaid is a a federal-state partnership where the money, most of it, comes from the federal government, although some of it comes from state governments too. And the eligibility rules mostly are set by state governments, although with some guidance and some basic restrictions and minimum requirements and the like set by the federal government. So what the Medicaid expansion did is it said, we are going to encourage every state to expand Medicaid in this way. We are going to pay for almost all of it. Federal government's going to pay almost all the cost. And if states refuse to do that, we are going to withdraw Medicaid altogether from their states. Right? No state is going to agree to have Medicaid withdrawn altogether, so it was a pretty strong incentive from the federal government. Kind of going along with this piece, the law included a bunch of additional provisions for more federal government spending to provide health insurance for folks, right? So for poor people, people below 133% of the poverty line, we're just going to expand Medicaid. They're going to get their insurance directly from the government. For middle class people, people a little bit above 133% of the poverty line, some of whom are still pretty poor, they're still going to have to get insurance through the private markets, but we are going to have a big new system of federal government subsidies to help them pay for it, right? So if the reason that you did not previously have insurance was because you couldn't afford it, right? Now, if you're real poor, the government's just going to provide for you. If you're less poor than that, you're going to have to buy it, but the government's going to give you a subsidy that's going to cover a substantial portion of the cost, right? So Medicaid expansion plus government subsidies is kind of one main provision of the law. Second major provision of the law is the regulations of insurance practices regarding pre-existing conditions and the like. Pre-existing conditions is just one example, although kind of the most famous and maybe most important one, but regulations of all the different kinds of insurance practices we were just talking about. They can't deny you coverage because you've been sick. They can't kick you off coverage because you get sick. They can't charge you more because you've been sick. They can't charge you more because you're a woman, which all insurance companies had previously been doing because female health care is more expensive than male health care because they might get pregnant, right? Every insurance company in the country was charging women more than men before this law. They can't do that anymore. They can charge you a little bit more based on age. The older you are, the more health care costs you're gonna have, so they can ratchet up the price a little bit, but there's restrictions on it. They can only ratchet it up a certain amount based on age. So all of those kinds of regulations of the private insurance companies. And the third major provision is the individual mandate provision. Which says that everyone has to have health insurance. Why is that an important part of the policy?
Wasn't that the part of the policy that was challenged for constitutionality?
It is. I mean, more than one was challenged, but that was the main one. Yeah, but why? But in policy terms, why is it important, Maurice?
That pays for it.
Yeah, how?
Because if you mandate that everyone have health insurance, everyone's going to have to pay for health insurance, and most people won't use it. Same like the car insurance.
I didn't crash into anybody. Why do I have to pay for insurance, right? I am not going to get sick or get hit by a car. That is my plan for the rest of the year. Nobody's going to hit me. I'm not getting sick. Why do I have to pay for health insurance? A, because nobody knows for sure when they're going to get sick or hit by a car. And B, because that is the only way to make insurance work. Healthy people have to pay money into the system in order that there is money available for the sick people. In addition, these two parts of the policy fit together. They kind of can't really be successfully separated. If you tell the insurance companies that they have to cover everybody, but you don't require people to have health insurance, I'm smart. I'm thinking, I'm not going to buy it till I get cancer. Then I'm going to buy it, right? And they are required to cover me. That is never going to work. No healthy people have insurance, and as soon as you get a diagnosis, then you buy it and they're required to sell it to you. How is that possibly going to work? There will be no money in the system. So those two things go together. The insurance companies said, they were in negotiations with the Obama administration, they said, we are okay with this. It changes how we've been doing things a lot. We are okay with it as long as this is in there, because then we know there will be enough money in the system to make it work. Okay? So that's the policy. That's 900 pages. It's way more complicated than that. That's the major parts of the policy. Republican members of Congress, Republican leaders of a number of states, independent organizations like the National Federation of Independent Businesses, which is a national organization of small businesses, challenged the policy in court. And they argued that it was unconstitutional. And they challenged multiple provisions But the main one that most of the attention was on was the individual mandate. And the challengers argued that the federal government, Congress, has no constitutional authority to require people to purchase health insurance, which is what this does, right? I mean, I should say what this provision actually says is everybody has to have health insurance or pay an annual tax penalty, right? There is now a question on your tax forms. I just did my taxes last week. There's a question on there where you have to check off whether you have health insurance or not. And if you do not, then your taxes go up, right? It's an annual penalty enforced by the IRS as a financial incentive to encourage everyone to have health insurance. The word mandate sometimes makes it sound like you're going to go to jail or something if you don't have health insurance. That's not how it works. It's just a tax incentive.
Do you know how much like the tax penalty is?
I don't know the dollar figure. It started quite low, and it was set to ratcheted up a little bit each year, so it's a little higher now. Most healthcare economists at the beginning said that they had set it too low, and it was not costly enough to, like, the penalty was cheaper than buying insurance for many people, so it wasn't costly enough to be an effective incentive. But it's something. Every time you filled out your taxes each year, you'd be like, oh, and then we don't have health insurance, so we're paying an extra $1,000 this year. Maybe next year we should go ahead and get insurance. But I don't know the actual dollar figure. And also, Congress just repealed it. So if you're filing your taxes right now for the 2017 tax year, it's still there. But for the 2018 tax year, unless they change the law again, it will not be there anymore. So focus on this individual mandate provision. How do we decide whether Congress has constitutional authority to pass this law or not? Where do we start? Yeah.
I think mostly they started looking at whether it was like a tax or a punishment, like the specific wording of like what that monetary like penalty or tax really was.
So they do look at that, but that's not where they start, right? That's not the main argument that the government relied on, or it's not the argument that the court addressed first, but they do get to it. So I'll come back to that.
They started by looking at the Commerce Clause and seeing whether or not it's a violation of that.
Yeah, and so spell that out for us a little bit.
Like, do you want me to say what they decided or what the argument was?
Yeah, start with the argument.
Okay, if I remember correctly, they basically said that like making everyone have health insurance was too far outside the scope of regulating commerce, and I think they also said that because it was like farther than interstate commerce was unconstitutional that way as well.
Mm-hmm. Right. So remember, Article 1, Section 8 says Congress shall have the power to regulate commerce among the several states. Right? We call it the Interstate Commerce Clause because the idea is it gives the federal government power over interstate commerce while state governments still have power over local commerce. Right? If commerce is just happening in one state, state governments regulate it. If commerce is crossing state lines, federal government regulates it. That's the idea from the beginning. And so the federal government's lawyers argue that the individual mandate provision and the rest of the law is a valid exercise of Congress's power to regulate interstate commerce. How do we decide if that is a persuasive argument or not? Where are we going to look? All right, so that's another clause, right? So let me do this. I got 4 provisions of Article 1, Section 8. The Commerce Clause, the Necessary and Proper Clause, the Taxing Clause, and the Spending Clause. All 4 of those are grants of power to the federal government, right? And the question is whether any of them authorize Congress to pass this law. So if we think of this as a grid, right? Right now we're focused on this, right? Does the Commerce Clause give Congress the power to mandate that everyone have health insurance? If you are a justice on the Supreme Court, what do you do to get started with thinking that through? Where do you look, Ted?
I would look at probably the most similar precedents I could find. You know, if there's any other insurance-related regulation that you could look to, maybe car insurance, because that's something that's federally mandated.
So the lawyers say, so for sure, right, we should look at other precedents, right? That's one thing the judges do. And the lawyers say, okay, well, car insurance is similar. Government mandates that everyone have car insurance. And the lawyers on the other side say, no, that's not really similar, because the government doesn't mandate that everyone have car insurance. The government just mandates that if you want a driver's license, you have to have car insurance. So it's still voluntary to you. If you are not driving, you don't have a car, you don't want a car, you don't want a driver's license, the government is not making you purchase car insurance. Whereas here, the lawyers on this side say, my client is just sitting on the couch doing nothing, and the government's making him purchase health insurance. So that precedent is similar in some ways. The lawyers on one side say it's similar, but it's different in some ways. The lawyers on the other side say it's different. What other things might we compare it to that might be helpful? Other exercises of federal power that might help us decide whether this one is legitimate or not. Colin?
Raising money for war.
Okay, tell me what that,
Well,
spell it out.
If you can make the argument that if Congress is able to, like, if it's deemed in the national interest to go to war, and Congress can raise funds during that time, can they also raise funds for another kind of general, like, the protection of people who won't protect themselves?
Okay, so you're focused on the raising funds part, right? Because the mandate is partly an effort to raise money for the system. And so I think that might fit better under this path, right? I mean, if what we're talking about is revenue, then a different part of Article 1, Section 8 says Congress has the power to lay and collect taxes. And it really doesn't put any limits on that. It doesn't say, I mean, it says Congress has the power to lay and collect taxes and provide for the common defense and the general welfare, like maybe those are connected, so if they were collecting taxes for some reason other than the common defense or general welfare, maybe you could make that case. But mostly it just says Congress has the power to lay and collect taxes. And so we could compare it to other instances in which Congress is raising revenue for what Congress thinks is the pursuit of the common defense or the general welfare, right? For sure, that's helpful. What about prior Supreme Court decisions that we have talked about? We're not experts on the technicalities of insurance law in here, but we have talked about some other cases about the limits of federal power.
So could you think about like other cases with like that justify, that are justified using the Commerce Clause, like Whitburn and Melbourne and the Heart of Atlanta, because they're not directly about commerce, but they're justified using the Commerce Clause.
Where would pick one of those cases and spell out what it might mean for here?
Okay, so like Heart of Atlanta, they say because they're denying the rooms to like black guests, but they're engaged in interstate commerce, so they're allowed to regulate it. The Congress is allowed to regulate it how they see fit, to adhere to the laws that they've passed. So same thing, even though it's not directly related to health insurance. Like health insurance is not. It is interstate commerce, so then they have the right to regulate it how they see fit.
Okay, right. If I run a hotel that is engaged in interstate commerce, then Congress has the power to tell me not to turn away customers on the basis of race, the Supreme Court said back in 1964. Right? What if I run a hotel that only serves local customers, or more likely a restaurant that only serves local customers?
So same thing, like so if it's a restaurant, they get their ingredients or like plates or anything that they buy, it's not all locally made. It's something in the process across the state lines.
So if we look pretty broadly at what counts as interstate commerce, then the federal power to regulate interstate commerce is pretty broad, right? One thing that the court has repeatedly said is that any economic activity that substantially affects interstate commerce is within federal power, even if it's local activity, right? I'm doing something with this other guy right here. I'm buying something from him right here in Syracuse, right? That activity in particular is local. But if it substantially affects interstate commerce, then the federal government can regulate it. How about Wickard versus Filburn? What else does that add to our thinking about this? That's the wheat farmer case.
Healthcare is a national market, so any individual's contribution to that market by buying healthcare is a participation in interstate commerce, and so they have a right to pass laws in that area.
And then with Wickard v. Filburn, it also adds in like the aggregation problem. So it's like an individual mandate, like okay, maybe if one person doesn't want healthcare, it's not a big deal, but then if a lot of people don't want to have healthcare, then it aggregates and becomes a substantial problem for the national market.
Mr. Filburn said, I am not engaged in interstate commerce. I'm not even engaged in commerce. I'm not selling the wheat. I'm growing the wheat for use on my own farm. And the government was like, yeah, but it's a dairy farm. You're feeding the cows with the wheat, and then you are selling the milk, so you are engaged in interstate commerce, A. And B, even if you yourself are not really engaged in interstate commerce, if we aggregate, you are engaged in some kind of economic activity, and if we aggregate it together with all of the other similar people engaged in similar activity, that has a substantial effect on interstate commerce. Right? So the substantial effects doctrine and the aggregation doctrine from these prior cases, the lawyers for the government, the lawyers for the Obama administration thought that gave them some pretty strong support. Right? This dude who says he's just sitting on his couch not buying health insurance, right? He himself does not appear to be engaged in interstate commerce. But if you aggregate his activities together with all other similar individuals who are choosing not to purchase health insurance, another way of phrasing that choice is are choosing to have their health care costs covered by somebody else when they get hit by a car. Same thing, different description of it. Right? If that is the choice they are making, aggregating all those people together, that has a substantial effect on the interstate health insurance market. We were just talking about that, right? There's tons and tons of people's costs going up because we got to pay for people's treatment in the emergency room and the like. Too many people with no insurance. The Supreme Court rejects this argument. Right? Supreme Court says, under the Commerce Clause, Congress does not have the authority to mandate the purchase of health insurance. Why? Despite Wickard versus Filburn and Heart of Atlanta Motel, why does the Supreme Court say no?
Because there are plenty of examples where the government doesn't provide for everyone's like needs in that manner. So to just kind of cherry pick it is not a strong enough or compelling enough argument for it.
So maybe Although what the government lawyers would say is, oh yeah, right, obviously there's lots of public problems and we haven't addressed all of them, right? But the question is, does the government have authority to address this one?
It was, they didn't know where to like draw the line, like in the case with the schools regulating guns.
Yeah.
Like the Supreme Court said that wasn't constitutional because when would you stop? I don't know.
Sure. So we talked about this case last time, right? So when Congress in the 80s passed a federal regulation of guns in schools, right? Federal crime to bring a gun within 1,000 feet of a school. Supreme Court said that sounds like an exercise of ordinary police powers. It's either a regulation of education or a regulation of criminal activity or both of which are ordinarily police powers that are in the hands of the states. And walking past the school with a firearm is not interstate commerce. And I know we've got all these prior decisions about aggregation and substantial effects and all of that, but there has to be a line somewhere, right? There's supposed to be a limit on federal power. There's supposed to be some things that only the states are allowed to regulate under our original constitutional system. And so we got to draw the line somewhere, and we think this goes too far. Okay, and so why might we think that the individual mandate provision also goes too far? Right? 5 justices of the Supreme Court said that. Like, what's the next step in that argument? Why is this similar? Why is it more similar to the Gun-Free School Zones Act than the wheat regulation? Why is it on this side of the line, or that side of the line? Whichever way you want to look at it. Yep.
Does that have to do with local versus national authority?
So that's part of it, right? Is we're saying, if I am sitting on, yes, there is an interstate market in health insurance, right? It's 17% of GDP, right? 17% of the entire U.S. economy is in the healthcare and health insurance industry. I'm pretty sure the federal government has some authority to regulate that as a whole, right? If it doesn't, something is seriously defective, right, with our Constitution, right? If the federal government cannot regulate a fifth of the national economy, right? But the question is, within that, individual people doing individual things, right, that are just local in nature, that are not, here's what Chief Justice Roberts says, we're talking about people who are not engaged in commerce, right? They are choosing not to purchase health insurance. Their decision is local in nature. They're not engaged in interstate commerce or commerce, either one. They're not crossing state lines or buying or selling anything. Of course, that was true for the farmer in the wheat case too. But an additional distinction, Chief Justice Roberts says, is they're not even engaged in any activity. Right? What we are talking about here is somebody who is engaged in inactivity, if that is even a grammatically correct sentence, right? Somebody who is not currently doing anything, right? The farmer was growing wheat, and we said that if you aggregate that together with other similar farmers in similar situations, that activity has a substantial effect on interstate commerce. And so the federal government can regulate it. This is different, Chief Justice Roberts said. Congress is trying to tell us that somebody's inactivity has a substantial effect on interstate commerce. And we think that goes too far. Is that a good argument? What do you think of that argument? Right? One reason the federal government cannot regulate this under the commerce power is because we're talking about dudes not engaged in any activity. We have said over and over again in the wheat farmer case and other cases that activity that substantially affects interstate commerce can be regulated by the federal government. But here now they're trying to regulate somebody's inactivity. Right? The decision not to purchase health insurance. That goes too far.
I guess yes and no, only because the inactivity, if multiplied, just in the same way that the farmer's activity is multiplied.
Yeah.
If the inactivity is multiplied, then it could also have a substantial effect like if everyone just not got on health insurance, in theory,
Sure.
that would change things.
Okay, so that sounds like no, right? Then it's not a good argument. But you said yes and no.
Yes, too, because just in theory,
Yeah.
some guy sitting on his couch is kind of messed up.
Yeah.
Like he's really not doing nothing, but we're gonna regulate him not doing nothing. It rubs me wrong.
Yeah. So, yeah. Other thoughts?
Do something crazy.
Yeah.
I think it makes sense until you think about you can sit around and do nothing and you can still develop cancer and then you still have to get health care. Like just because you're not actively doing anything doesn't mean you couldn't develop some huge disease that would cost lots of money and therefore affect the market.
Right. If you ask economists, they tell you this distinction makes no sense at all, right? The way an economist thinks about the world, they're like, all we're talking about is a dude deciding to have somebody else pay for his healthcare costs, right? That is the economic decision he is making. Everybody has healthcare costs sometime. Nobody never ever gets sick or in an accident. Everybody has some healthcare costs. And you are deciding either to pay them yourself out of pocket, if you have money, once they come, or you're deciding that somebody else is going to pay them when you visit the emergency room. That is an economic decision, just like deciding to purchase insurance is an economic decision. Deciding not to purchase it is also an economic decision. They're not really any different. But gut-wise, instinct-wise, some people have the kind of, Maurice's second reaction, like the, like sort of libertarian, like, why can't, the government's telling me I can't just sit here on the couch and do nothing. That doesn't seem right. That is for sure the gut reaction that lots of Americans had to this provision of the law. You have a question?
Well, I was thinking, that's actually, seems like quite an unhealthy lifestyle. So
Yes, right. Yes.
Something bad is probably going to happen to you at some point.
So here is another analogy that Chief Justice Roberts drew. Many people, many Americans, do not have healthy diets. Many Americans go through life never purchasing broccoli. Can the government mandate that you purchase broccoli? For Chief Justice Roberts, that is a rhetorical question, right? Obviously not, he says. And so they can't mandate that you purchase insurance either. I'm actually not totally sure. The government cannot mandate that you eat broccoli. I think that is a clear violation of constitutional liberty. And order you to go to a store and purchase it, okay, if that's what we are talking about, that sounds like a violation of constitutional liberty. But what we are actually talking about is a tax incentive that said, if you purchase broccoli, your taxes will be lower this year. If you don't purchase broccoli, your taxes will be a little bit higher. And the government does that all the time. As soon as you purchase a house, your taxes go down because there's all these tax incentives for home ownership. Right? So from one angle, the government is telling people what to do, going just way too far in regulating individual, local, non-economic activity, not even activity, inactivity, right? And from another angle, this is obviously a regulation of the health care system as a whole, which is obviously interstate commerce. The system, all these parts fit together. Remember, you take away this part, and this part doesn't work, right? It is a overall, just like the agriculture regulations in the New Deal, were an overall regulation of the market for wheat and other commodities. And in some applications, right, most of the wheat farmers are big. They're buying and selling lots of wheat across state lines. But are there some wheat farmers engaged mostly in local activity that does not have that much to do with the big, giant interstate wheat market? Yes, there are some of those, and the law can still apply to them. Right? Same thing the court said in the marijuana case we talked about last time. Right? Is there an interstate market for marijuana? Yes. So can government regulate marijuana sale and possession under the Commerce Clause? Yes. But what if I am growing 2 plants in my closet for my own personal use? I am not engaged in commerce or doing anything interstate. Government can still regulate it, the court said, because it's all connected together. If everybody's allowed to grow weed in their own house because they say they're not selling it across state lines, that is going to mess up the overall regulatory scheme, I think. Right? So, the gist of it is, if you read Congress's powers flexibly and broadly, as the court has often done through much of its history, then I think the Affordable Care Act fits pretty well with those powers. If you read federal powers more strictly, as the court has periodically done, including in a couple recent cases that we talked about last week, like the Gun-Free School Zones Act case, then this one starts to look more like it went too far. Right? Chief Justice Roberts writes the main opinion, and Justice Ginsburg writes the main dissenting opinion, and they disagree really sharply on this question. I want to point you to one part of Justice. I got quotes from both of them on the handout, but let me point you to Justice Ginsburg to start. Go ahead and skim that whole quote from Justice Ginsburg. What do you get from that? What's Justice Ginsburg driving at? Yeah.
I'm saying that by striking down the provision, you're basically going back to what we already said.
Like what doesn't work?
How the states were pretty much incompetent in regulating any of this.
Yeah, and when?
It was really consistent to have a federal entity regulate it.
And when is she referring to?
The
Yeah, she's going way back, right? We wrote the Commerce Clause because of the disastrous economic situation under the Articles of Confederation leading up to the Constitution, when states were engaged in trade wars with one another, right? Federal government had no effective authority to do anything, right? Couldn't stop the states from fighting with each other, right? Imposing tariffs on the importation of goods from like New York to New Jersey, right? And it couldn't also effectively engage with other nations because like we couldn't enter a trade deal with France or Britain because the federal government had no way to control what the states were going to do. Britain would be like, why am I going to sign a trade deal with you when New York and New Jersey are still going to change their rules however they want, right? What was the central purpose of the Philadelphia Convention in 1787? Yeah.
Create a new and more powerful federal government.
All right, you get an A in comma 1, right? Last semester, if somebody does not remember that, I'm going to go back and change your grade lower from last semester. Just kidding. Right? I said it like 100 times last semester, right? The central purpose of the Philadelphia Convention, build a new and more powerful federal government. Right? That is the central purpose. Not the only purpose, but that is the central purpose. That's why they assembled together. The federal government was busted. It did not work. It could not provide for the common defense. It could not promote the economic prosperity of the American people. It was busted. And we needed a new and more powerful one. And look at the bottom of Ginsburg's quote there. Right? You will note from the little internal quotation marks there that she is quoting some other people in the midst of her opinion. The framers' solution was the Commerce Clause, which, as they perceived it, granted Congress the authority to enact economic legislation, quote, in all cases for the general interests of the Union, and also in those cases to which the states are separately incompetent. Where's that from? Somebody really gets A in comma 1. They can come up with this. Where's that from? Does it sound familiar?
Is it Carolyn Products?
Nope. No, it's from way back at the beginning. Yep.
Is it from one of the Federalist Papers?
Close, but earlier than that. It's from one of the authors of one of the Federalist Papers. Yeah. It's from James Madison's Virginia Plan, which was the first draft of our Constitution. He showed up, right? He's like, I know how we're going to control the debate in this. We need a new, more powerful federal government. I'm going to go ahead and write the first draft and introduce that. And people argued about lots of parts of it, and they changed lots of parts. But that's what structured the discussion. And he said that the federal government should have authority to regulate on any matters in the national interest, right? Any matter on which the separate states are separately incompetent, which doesn't mean incompetent the way we think of that. It means any matter on which the separate states could not effectively regulate on their own, right? So purely local economic activity that's only happening in Syracuse, New York can handle that. But any economic activity that involves more than one state, the separate states are incompetent to regulate on their own. They cannot effectively handle that. And so, therefore, the federal government should have authority over it. That is the meaning of the Commerce Clause. Justice Ginsburg says, right? We were trying to create a government that can effectively regulate all economic activity that's in the national interest to regulate at the national level. Chief Justice Roberts, in his opinion, responds to this part. He's like, "That what the Virginia Plan is not in the Constitution, right? Those are good words written by a good person, James Madison, but they did not make it into the Constitution, right? Those words are not in our Constitution. That was just a draft. You can't quote from the draft. They didn't adopt that thing. They changed it up, right? The words that we actually got." Our Congress has the power to regulate commerce among the several states. And this dude, sitting on his couch, not buying health insurance, is not engaged in commerce among the several states. And so Congress can't regulate it. That is two fundamentally different visions of national power under our Constitution. And the court is sharply divided, 5-4. When the decision came down, a bunch of the journalists at the Supreme Court waiting for the decision messed up, and CNN.com actually briefly had Supreme Court strikes down Obamacare as a big banner headline across the top of the website because Roberts has this long section. Right? This is one thing that drives journalists crazy. Supreme Court doesn't give you, like, cliff notes. They don't give, like, advanced briefings. They do not tell anybody in advance. They just drop a box full of opinions, like, on Monday morning, and the journalists, like, grab it and start flipping through it. And when there's a big landmark case that everybody's waiting for, there's more journalists there than usual, and some of them are not as expert on the Supreme Court as the ones who are there, like, every day for all the minor cases, you know? So they mess up sometimes. But also, the way Roberts wrote it was weird. He has a long section in the opinion holding that the individual mandate provision is not a valid exercise of the commerce power. And then he upholds that provision anyway. He also says it's not a valid exercise of the necessary and proper clause. That's in there too. And then he says, it is a valid exercising of the exercise of the taxing power. Congress has the power to lay and collect taxes. That's all this provision is, right? It says if you have health insurance, your taxes are going to be somewhat lower. If you don't have health insurance, your taxes are going to be somewhat higher. There are lots of other provisions in federal tax law that work in a similar fashion. It's a tax provision, and it's perfectly within the scope of Congress's power to lay and collect taxes. Chief Justice Roberts is basically the only one who liked this argument, right? 4 of the justices say this is a valid exercise of the commerce power, which was the main focus of the arguments. 4 of the justices say it is not a valid exercise of any of these powers. And Chief Justice Roberts says it's not a valid exercise of the commerce power, but it is a valid exercise of the tax power. He's the only one who says that. And there's been lots of speculation about why did Chief Justice Roberts do it like that. nobody knows. There were reports leaked from inside the court, which is unusual, but it happened this time, that Roberts had initially voted privately to strike the law down, and then during the course of the deliberations and writing the opinions, he changed his mind at some point. And some speculation was that he was worried about the impact of the decision on the institution of the court itself, right? It was 2012, it was June of 2012, it was an election year, right? Signature domestic policy achievement of President Obama, who's currently running for re-election, and the Supreme Court was about to strike it down by a 5-4 vote with 5 Republican justices in the majority and 4 Democratic justices in dissent. I'm pretty sure there might be reason to think that would have some negative impact on the court's reputation, right? And so maybe it was a strategic move because of that, but we don't know. Maybe he just read all the arguments about the taxing power and he found them convincing. One thing Ginsburg did point out in dissent is that if the court was following its normal procedures, if the law is a constitutional exercise of the tax power, then you do not need to talk about the commerce power. Right? Remember the court likes to decide just things one at a time, incrementally, just deciding what it has to decide. If it's a valid exercise of the tax power, then the Commerce Clause arguments are irrelevant. And there is no need to spend 30 pages or whatever it is pushing a narrow view of Congress's commerce power that is not relevant to the case anymore. If you're upholding the Chief Justice Roberts is like, yeah, but he has an answer to that in the opinion. You can look at it yourself. It's in the part that's in the book. He says, yeah, but the Commerce Clause was their main argument that they put the most weight on, so it seemed important to address that one first. I don't know. That does not really make any sense. That's not how the court usually rolls. I'll just say it like that. That is not what the court usually does. Usually they take the arguments and they decide the case on the narrowest possible grounds, and once it's decided, they don't go on and continue to address other things.
So if they found that it broke, like, or was unconstitutional in a few different sections, why was any of it upheld? Just because, why does the taxing clause trump the other ones?
Because the question is just, does Congress have the power to enact this law or not? And Article 1, Section 8 gives Congress a long list of powers. And if any of them give Congress the power to enact this, it's not like it violates a prohibition. Like, the way the First Amendment is phrased, Congress shall make no law abridging the freedom of speech. That's a prohibition on congressional power. But these provisions are all grants of congressional power. So as long as one of them fits, then Congress can do it. Another big issue in the case at the time, this is somewhat more technical, but it would have significant practical consequences, is the lawyers who were challenging the law, most of their focus was on this provision, the individual mandate provision, but they were arguing that the law was not severable, right? That if you struck down this provision, you would have to strike down the entire law, the whole 900-page law, because it's all supposed to fit together. And so they were attempting to persuade the court to strike down the whole thing, but they'd have to persuade them to strike down that part first. The court also focuses on this provision, and in the time we got left, I want to tell you a little bit about this one. Remember the case we talked about last week about highway funding, right? South Dakota versus Dole. Federal government passed a law that said, here's a bunch of federal money to build and maintain highways. We're going to give it out in grants based on some formula to each state. If your state has a drinking age lower than 21, we're going to cut your allocation by 10%. So it was a federal incentive for states, like something like 30 states at the time had lower drinking ages. Federal incentive for states to raise their drinking ages to 21 for the obvious reason that a higher drinking age is going to reduce drunk driving and reduce highway accidents and the like. So that's the connection to highway funding. The laws regarding the drinking age are set at the state level, right? How old do you have to be to lawfully purchase alcohol? That has always been an exercise of the police powers, exercised at the state level. And so Congress is not allowed, under the Constitution, to pass a national drinking age law. But that is not what Congress did. Congress is allowed to spend money to build and maintain highways, and Congress just put a condition on that. Said it's totally up to you. States, you can set whatever drinking age you want, but if you want the federal government to build and maintain highways, in your state, you got to raise it a little bit, or we're going to reduce that funding. That is the same thing that Congress did with the Medicaid expansion. Right? It said it is voluntary for each state whether they want to expand Medicaid up to cover everybody up to 133% of the federal poverty level. Voluntary for each state. But it's federal money, right? If you expand it, you're going to get the federal money. And if you don't expand it, you're not going to get the federal money. And you're not only not going to get the new federal money in the Affordable Care Act, you are going to lose all federal Medicaid money, which is a lot of money, right? There are already lots of people on Medicaid before the Affordable Care Act. It's millions and millions of dollars in each state. In some states, the federal contribution to Medicaid, not uncommonly, is like 10% of a state's entire annual budget, right? It's an enormous amount of money, right? And the lawyers argued, the lawyers challenging the law, argued that this provision was an unconstitutional exercise of Congress's spending power. And on that one, they won. The Supreme Court struck this provision down. By which I mean, they said it's voluntary. They did not get rid of the Medicaid expansion. They said the federal government can't compel states to do it by threatening to withdraw all of their Medicaid funding. The size of that financial incentive is so enormous, Chief Justice Roberts said, that it is a gun to the head of the state governments. That is his phrase. Right? And Congress can't do it. They can't force states to do it. Right? And so it's voluntary. Right? Whether states expand Medicaid instead of more or less mandatory as the law intended. Ginsburg disagrees with him on this one too. If you're sticking with the court's precedents, it seems like the government can do this because the government's done it a bunch of times and the court has always upheld it. South Dakota versus Dole is one famous example, but there's a bunch of other cases too. A bunch of civil rights laws do this. Will withdraw federal education funding from your school if you're not desegregating, that kind of thing. On the other hand, so on the one hand, if you're looking at the court's precedents, it seems like the government can do this. On the other hand, it is for sure true that this is a larger federal spending condition than the government had ever imposed before, just in terms of the scale of it, the size of federal money that we're talking about. It's much larger. And so Chief Justice Roberts is like, this one is so big that it amounts to an unconstitutional effort to like extort the states into doing something that they might not want to do. And so it's voluntary. One question for lawyers and constitutional scholars is whether this part of the decision striking down the Medicaid expansion, whether it's going to lead to like renewed litigation. I was going to say attacks, right? But that's kind of polemical, right? Renewed, like more active litigation, trying to challenge all kinds of other federal government conditional spending policies. Because again, the federal government does this a lot, right? They do it in all kinds of different policy areas. And are there going to be challenges to all these other ones now based on this precedent? One example of it, with the political tables turned, is that the current federal government, Trump administration, and Attorney General Jeff Sessions have repeatedly threatened to withdraw federal funding from local government jurisdictions and universities that declare that they are sanctuaries for immigrants and will, to the extent that the law allows, they will refuse to cooperate with the apprehension, detention, and deportation of undocumented immigrants. And Attorney General Jeff Sessions has repeatedly said we're going to withdraw federal funding from your state and cities if you keep doing that. That is currently being litigated in California right now, and California's arguments are, Affordable Care Act case. Remember that one? Federal government can't pull all our funding just because they're trying to compel us to do this one thing. So we'll see how that one plays out. Just last point on the Affordable Care Act. So the upshot of this decision, right? The upshot of this decision is that the court backs down from like a major confrontation with the Obama administration during an election year, right? The headline news is, once they corrected the headline on CNN.com, court upholds Obamacare. That's the headline news the day after the decision. They uphold its most important provisions. Those provisions took effect. They have worked well in some ways and less well in other ways. They have significantly expanded health insurance coverage, for sure, nationwide, cut by many tens of millions the number of people without health insurance. But a major part of the law's effort to reduce the uninsured population is this part. And initially, virtually all states led by Republicans refused to expand Medicaid. Right? Remember, every state was supposed to expand Medicaid, but the Supreme Court says it's voluntary. Every blue state went ahead and expanded it. Initially, all the red states said, no, we're not going to expand it. Some of them have come around, right? Governor Kasich in Ohio signed an expansion of Medicaid. Some of them have not come around. Some of them are still arguing about it. There's a big argument in Virginia right now about this. The governor of Virginia wants to expand it, but and there's some support in the legislature, but they don't quite have the votes. That has, I meant to look up the latest numbers before today. I think there's something like 10 million people who are still uninsured because they would be eligible for the Medicaid expansion, but their state has chosen not to expand it. And the last point about this, just to come back to the policy, this is one thing that happens if you start drawing the Supreme Court into your policy conflicts, right? In the states that have refused to expand Medicaid, right, the subsidies for middle-class people are still in place because that's a different part of the law. Nobody struck that down. But the Medicaid expansion for poor people is not in place. So in states like Virginia, if you make more than 133% of the poverty level, you are eligible for government subsidies to purchase private health insurance. But if you make less than that, you are not eligible for the Medicaid expansion because of the Supreme Court decision. That does not make any sense to anybody. The government's providing more help to middle-class people than poor people to get health insurance. That is not the law that Congress wrote, right? But that is the law that's left over after the lawyers persuaded the court to X out part of it. And that is what happens sometimes, and obviously we are still trying to figure out what to do with that. All right, that's all. Make sure you give me your paper if you have not done so. Next question.